Hi everyone, we're gonna get started now. Bear with me while I figure out this microphone. All right. Hi everyone, my name is Christian Santana. I use he or they pronouns, and I'm the staff attorney here at the QLaw Foundation of Washington. Thank you so much for everyone who made it. The next hour and a half is gonna be basically just a little discussion, know your rights on tenant renters' rights here in Washington State. I'll be providing some information, and then our wonderful peer navigator, Stephanie, will also be talking about some resources that are available. And at the very end, we'll have a Q&A, and then we also have two tables, one right here, one at the front, with some resources. So that's kind of how the evening's gonna go. So before we start, who is the QLaw Foundation? We are a tiny but mighty 501c nonprofit. Our goal at the QLaw Foundation is to promote the dignity and respect for LGBTQ and Two-Spirit plus Washingtonians within the legal system through advocacy, education, and legal assistance. So we have a couple programs here at the QLaw Foundation. Our most active one is our LGBTQ legal clinics. So what we offer are free 30-minute consultations with our volunteer attorneys or with myself on any legal matter that's not criminal, basically. So if you have a question on immigration, housing, anything relating to tax law, whatever the case may be, we are happy to help kind of just get you started. We can offer some resources as well, kind of point you in the right direction. And we do have some space for legal rep as well if that's needed. We also have our peer navigator program. So this is kind of outside of the legal parameters. So let's say that you need help filling out some forms. Forms can be overwhelming at times. Let's say you need help maybe going to court or navigating these crazy systems, that are benefits, that are, resources. Our peer navigator is available to do that. We also have our attorney referral network. So again, when you need a referral to an attorney, beyond the 30-minute legal consults, what we do is we have a network of attorneys, folks that we have worked with or that we have screened that are LGBTQ affirming, right? So you're not just kind of jumping in blindly, not knowing whether or not these folks are gonna respect your identity and your identity as a queer person. And we're also do public policy advocacy. So around legislative session, what we do is we try to help advocate for laws that we believe benefit our community and Washingtonians at large. So housing, basically, most of it is governed by Washington's Residential Landlord-Tenant Act. That is RCW 59.18, RCW standing for Rules of Conduct of Washington, 59.18. It's super dense. The goal here is to try to make all the laws as understandable, I guess, as possible. The RCW is actually really, really vast. Housing law is super vast. We're not going to be able to get through everything in the time that we have, but my goal is to kind of provide an overview, get as much information as possible, and then of course, if you have any follow-up questions, you can ask, or I'll be sticking around afterwards if you want to kind of get deeper into it. That RCW is state law. There's also local laws which provide additional protections. So Seattle typically offers more protections than the state does. And when that's applicable, I'll be sure to let you guys know what further protections Seattle might have. But bottom line here is that a lease cannot waive most of these statutory tenant rights, meaning every single lease in Washington State has to follow the following laws that we're going to talk about. So the way we're going to talk about all of these laws, we're going to kind of go through the life cycle of a lease, starting from looking for an apartment, and then signing the lease, what your rights are while you're renting, and then the end of the lease, whether you are renewing, whether you're terminating, or whether you are leaving early. But before we get into that, it's just some general advice. Read everything, right? Your lease is a contract, right? And even though they all look similar, they can vary drastically on a lot of different topics. For example, some Some leases include utilities already. Others might not. Some are a fixed fee. Some of them you have to register, with the utility and pay on your own. So that really varies. Every lease has a different rule on guests, whether they can stay for a week, 2 weeks. Parking, right? Some places parking is included. Others you have to pay. Other places might not offer it at all. And then pets, of course, really important. A really big resource, a lot of things that people ask for are emotional support animals. So we actually have a resource on that, which if anyone is ever interested in what that process looks like, there are some places that don't allow for pets, right? Or that have a pet rent. But if you have followed through a specific process where you need a pet, what that does is that waives the option for you to not have the pet or for you to pay that pet rent, if that is something that you might qualify for. We do have some resources over there, and I'm happy to go through it further because it's a little bit of a process, but it's a really important right that one might have. And the second big piece of advice is keep every major interaction, keep a record of it in writing. That includes proof of whenever you pay rent, requests for repairs, evidence of any landlord violations, any incidents with neighbors. It doesn't have to be written down on a paper with printed out. Written evidence also include text messages. It includes emails. It includes even just any a post-it note that your landlord might have given to you. All of that is evidence that is valid for keeping track of any incident. So in case any legal problems do arise, you having those interactions in writing is the best way for you to prove whether or not a specific incident happened, if that makes sense. So we're gonna start off with applying, right? Let's say you found an apartment that you really like. So again, going through the life cycle, first step, we see an apartment, we really like it. Fair housing protections. First thing we need to know is that here in Washington State, we have quite a bit of protection against discrimination, more so than nationally even. So when you're looking for an apartment in Washington, you cannot be discriminated, not just for renting the unit, but the prices as well, the promotion of the unit, anything like that. You cannot be discriminated on the basis of your race, nationality, religion, sex, and that includes your gender identity, gender expression, familial/marital status, disability, sexual orientation, age, political ideology, source of income, and that includes if you do use assistance like Section 8 housing or veteran status. That's the case all around the state. However, in Seattle, you do have a little bit more protections in that when you are applying for housing in Washington, if you meet the requirements for that apartment and you are the first person in line, you have to be offered that spot. So again, landlords cannot screen for who they deem as more worthy of that housing, right? So assuming that you are the first applicant, you meet all the requirements, you must be offered that apartment unit. So when you're applying for housing, you've got a couple of fees throughout the process. You've got the two biggest ones being screening and holding fees. For screening fees, this is when a landlord, they have a right to get some more information from you, a little bit of a background check, so to speak. They can charge you for that screening, but they can't charge you for more than how much that screening costs them. Typically, the cost of that screening is $30 to $50. And another important thing is if you are denied or if that screening, it seems kind of questionable, you do have a right to access that screening. You have a right to dispute whatever is on that screening. So it's important to know, right? If for some reason you are denied that housing, it's absolutely your right to know why. It's absolutely your right to contest that specific reason if it's inaccurate. There's also holding fees, right? Sometimes specific apartments are very desirable. A lot of people want to apply for it. If you are applying and you really want it, right, and you want a landlord can hold that apartment for you while your application is processing, they have a right to ask for a holding fee. What that means is that you put a deposit down while your application is processing. The holding fee cannot be more than 25% of the first month's rent amount. So if the first month's rent is $2,000, it can't exceed $500, for example. If you decide not to move in, the landlord can keep the fee, right? Because that's the risk of you holding it down, for example. But if you do decide to move in, that holding fee must be applied to the deposit or the first month's rent. An important distinction here is that landlords can't charge for being placed on a waiting list. So if you're not first in line and you want to be on that list, that's a very specific situation different from holding fees, and you cannot be charged for that, basically. So that kind of covers initially, right, looking at apartments. Once you start the next process, right, you find an apartment you really like, you start to move in. So most places, when you move in, they have what's called a security deposit, right? It's for landlords to ensure in case any damage is done, they'll have that specific amount. But however, for a landlord to charge you for a security deposit, they have to provide a move-in checklist, for example. And what that has is that has the conditions of the apartment that you all have to agree on those specific conditions. For example, it'll have the conditions of the floor, it'll have the conditions of major appliances, it'll have conditions of the walls, for example. This is gonna be reviewed twice, when you first move in and at the very end when you move out. It's super, super important when you do move into the apartment that you do this checklist, do it thoroughly, because if a landlord wants to keep any portion of that security deposit, they have to demonstrate what needs repair beyond the regular wear and tear. It can't just be the floor is getting the carpet getting a little worn out, for example. That's regular wear and tear. But if the carpet is torn, right, if it's torn up, and it wasn't like that, then they have a right to keep a portion of that security deposit. However, if it was torn up to begin with, then it's important to note that so that you won't be charged for that at the end of your lease. Again, make sure you note the conditions of the walls, the floors, the appliances. Regular wear and tear is fine, but anything beyond that, they can take that out of your security deposit. Security deposits vary in amount, but if your total move-in costs are more than 25%, so a quarter of your first month's rent, you can actually ask your landlord for a payment plan. You can spread out that move-in cost within the first 3 months, which I think is pretty cool. Because sometimes, I don't know about you guys, but when I rent an apartment, the first month rent, security deposit, all these fees, it can add up pretty quickly. So you can actually spread that out, and that's within your right to do so. While you're renting an apartment, you have a right to ask for both reasonable accommodations and modifications. Two different things, which we'll go through right now. An accommodation is a change in rules, policies, practices, or services that allow you the equal opportunity to use and enjoy a dwelling. So what that means is kind of like a change in the rules that is reasonable for you to enjoy your living situation. For example, if you have a difficulty moving up and down the stairs, it's super reasonable for you to ask for a floor unit, for example. A service animal, if you need one, right, even if the lease says no pets, that's an accommodation you can ask for. If you have difficulty walking, you can ask for a parking space closer to your apartment. These are all things that, can be provided by a landlord. Another accommodation that I learned about, which I think is pretty neat, is if you, for example, receive public benefits, and let's say you receive benefits every third of the month, but your rent is due on the first. A reasonable accommodation that you can ask for is for you to pay on the third of the month instead of the first. And again, a small change, but if it's helpful for you, you are within your right to ask for that accommodation. A modification is different. A modification is a physical change to the property that would allow you to make it more accessible for you to live in. So for example, if you need to widen the door frame because you need a scooter to drive through, if you need a bar in the tub for you to help get you in and out of the tub. These are things that are also a right for you to ask for. Typically, these are what's it called? You have to do it yourself. You have to pay for those costs. And the owner, the landlord, has a right for them to ask you to return it to the original position. But again, that's within your right. If it's something that's required for you to live in that unit, you absolutely have a right to request it. And unless it's incredibly unreasonable, a landlord shouldn't deny it. Accommodations typically don't have a very high cost. They can be like asked for, and they typically don't require like high costs. So those, again, unless unreasonable, a landlord should respect that request. They should be made in writing. Again, a lot of these things really important. Try to get it in writing. Try to keep that record in case landlords try to contest it, try to say you never made that claim. It's best to keep everything in writing because a landlord almost always will. Again, emotional support animals, that's a really great way to have a pet in a place that, for example, might not allow pets. They'll say on the lease, right, no pets. However, if you do qualify, and what that means, short and long-term short, is that if you have a professional letter from a licensed mental health professional in Washington State, and they write out a letter saying that you do qualify for this program, then you have a right to have that pet in your apartment, regardless of whether there's a no pet rule. You shouldn't be charged any pet rent, any pet deposit. We'll have some more information on that, what that looks like, here on the side. So you moved in, and now you're living in your apartment. You have rights that we're going to kind of go through. For example, you have a right to live comfortably in that house. You have a right to make sure that all major appliances stay up to date. We'll be going through what that looks like and how you can make a request if something isn't working the way it should. Yeah, so now we're halfway through the life cycle of your lease. So you have a right to repair for all major things. For example, the standard is anything fit for human habitation. What does that include? That includes functioning heat, water, including hot water, plumbing, electrical, major physical structures like roofs, floors, walls, the foundation, your carbon monoxide and your smoke alarms, and all major appliances. So if these things aren't working, your landlord has to get it fixed, and because it's essential to your enjoyment of the premises and even to like basic human habitation, right? If something isn't within this list, it's more like extra, I guess. Like, let's say you have an apartment with a built-in chocolate fountain, and it breaks. Technically, a landlord doesn't have to replace it, but for these major ones, it's absolutely essential. If it's not functioning as it should, what you should do is you notify your landlord, your property manager, in writing, again, and we recommend that you deliver it to them personally so that so you can, like, if they contest it, right, if they take too long to fix it, you have, like, testimonial proof that you gave it to them. Once you do, they have a specific time frame to fix these problems, depending on what it is. If it's fixing hot or cold water, heat, electricity, anything that's imminently hazardous to life, you have 24 hours. They have 24 hours to fix it, because these are pretty essential for living, right? If there's a broken refrigerator, broken appliance, like an oven, major plumbing issue, they have 72 hours. That's 3 days to fix that issue. Anything else that's not mentioned on those two lists, they have 10 days to fix. If they don't fix that defect in time, and you've given them that notice, right? You've given them notice that your oven isn't working, 3 days have passed. What you can do, you have a couple of options. You can write a demand letter, and that's something that we're happy to help you with if you ever run into that issue. And basically, it's you saying, hey, landlord, the law says you need to fix this, you haven't fixed it by then. If you don't comply, we have a right to sue for damages in small claims court. And hopefully, at that point, the landlord will comply. But if not, then you can actually follow through with that lawsuit if necessary. You can try to settle the dispute through mediation. And for example, let's say they're like horrible landlord, horrible building. He hasn't been working for like 5 weeks after multiple notice. You actually have a right to move out mid-lease. You should not have to pay any of like early termination fees in those specific instances, and you may be able to get your deposit back in those, again, in that specific instance. But if you decide to move out, I would recommend talking to an attorney first, maybe making a consultation with our legal clinic just to make sure that you follow cross your T's, dot your I's, just so that they don't try to like sue you for, or they try not to like pin it on you leaving early, and you can actually say, well, no, I actually have this following evidence that you ignored my request to fix the heating, or my oven hasn't been working for a month. So yeah, that's kind of what you have. There's a couple options there. If your landlord is ignoring your right to get things repaired. The last option that you have, you can do what's called repair and deduct. So if, for example, your refrigerator's been broken for the past 2 weeks, it's beyond that deadline of 72 hours, what you can do if you're up to date on your rent, on your utilities, and you've given notice to your landlord, you can do what's called repair and deduct, where you make the repair yourself, either like literally you, or you hire a professional, and then you can deduct the cost of that services from your rent. Before you do that, though, we really, really do recommend talking to an attorney, because this specific repair and deduct process, there has to be really specific requirements that can be met, and if they're not, then the landlord can say, well, why did you fix it, right? So again, before withholding rent money, before making any major changes, we do recommend talking to a professional before going through this process. But it is within your right to repair it yourself if it's past the 72 hours, 24 hours, whatever the case may be, and you're being ignored. That is an option available to you. Next thing we're going to talk about is roommates versus guests, right? A lot of us like having folks over. Sometimes we'll have a friend, a family member stay in town for a week, 2 weeks, whatever the case may be. That's absolutely within your right to do so. However, every single lease says something different. For example, some leases say you can have someone overnight for 7 days, not a problem. Some say 14 days. That's determined by your lease, and so you should, before signing any lease, just make sure that you know what policies are applicable in your specific instance. Why does that matter? Because if you are in a landlord-tenant relationship with in a specific unit, you can't just be kicked out. You have to go through the eviction process, which is a very long process, and a lot of requirements have to be met before you can be kicked out of your apartment, basically. And so if the most obvious way to have that landlord-tenant relationship is signing the lease, right? Because once you sign the lease, then it's clear that you have that landlord-tenant relationship. However, there are other ways that you can establish tenancy within a specific apartment. There's a process called becoming a tenant at will. What that means is, let's say you have a friend that stays over, and at first you're like, they're only going to stay for a couple days. A couple days becomes a couple weeks, and before you know it, they've been there for 2 months. They've paid you a little bit for rent. They change their address to your address. They start receiving mail there. If enough of these requirements are met, what can happen is they can actually become a tenant. And what that means is, let's say that you don't want them there anymore, and you're just like, hey, friend, kind of overstayed your welcome. It can make things really complicated if they've established tenancy at will, because you can't just kick them out, right? So, and again, a court looks at things like whether they pay rent, whether they moved in a lot of their stuff or not, whether it's their primary address, whether they receive mail, how long they stay there, just things to consider, right? So if you do have folks over long term, it's just things that you need to think about because these things can actually have legal repercussions if enough of these situations aren't met. A landlord does have a right to enter your home, but specific things have to be met. First of all, they can't just enter anytime they want. It has to be usually at a reasonable time. What's reasonable? 8 a.m. to 6 p.m. typically, and they have to give written notice. They can't just verbally tell you, hey, I'm coming over tomorrow. They have to provide written notice of the exact date, specific time window that they plan to be at your building. And they have to have a specific purpose. They can't just come like to hang out, right? I mean, they can ask you if you want to hang out, but you can't, they have to have a specific purpose to enter your home when in the role of like a landlord, for example. If there's repairs, inspections, maintenance that has to be made, they have to give you 48 hours notice in writing. If the end of your lease is coming up, they're trying to show it to other folks, they have to provide you 24 hours notice when showing it to prospective buyers or tenants. And if there's an emergency, if like, for example, you're out of town and the apartment starts flooding, if there's a fire, if they smell gas, then they don't need notice because that's an emergency. So you've lived there for a while and you kind of want to move out for many different reasons. How you move out also matters depending on the situation that you're in. So for example, let's say you signed a 1-year lease and after that 1 year you no longer want to live there. That's fine, that's great. Technically, you don't have to provide notice because that lease says the date that you are moving out. However, it's recommended that you do kind of give 20 days notice, or at the very least, talk to your landlord, make sure that they know that you don't want to renew. Not necessary, but it's good to kind of have that communication just so that there isn't any miscommunication, to avoid any potential problems that might arise as a result of that. However, if you are month to month, which again, sometimes after your year lease, it'll turn to month to month automatically. You have to provide 20 days written notice before you move out. In writing, preferably. If, let's say you signed a 1-year lease and you, for some reason, have to leave earlier, there's a couple options in which you might not have to pay any early termination fees. However, if you don't meet any of these, it's very possible that they keep part of your deposit. We'll get into that, but there's a couple ways to get out of a lease without any problems. These are your defenses against early termination. So, for example, the first one is if you're in a domestic violence situation, if you need a protection order, if you no longer feel safe in your home. What you do is you get a letter by a qualified third party. That's a social worker. That's someone who works in a domestic violence shelter. If they write a letter saying that you're in a situation like that, you can move out without any consequences to an early lease termination. Like, they can't charge you for leaving early. If you're active in the military, you have to go. If you have to go and you're in inscription in some other part of the country or the world, then you don't have to pay anything because you're required to, right, by the military. If there are severe habitability issues, for example, right, again, talking about you haven't had heat in months and it's the middle of winter, that's a severe habitability issue. If your refrigerator has been broken for months, your landlord doesn't care at all, that's a severe habitability issue. You have a right to move out without those consequences of an early lease termination. Another big one that people don't talk about enough is mutual consent. If you talk, again, many people think that if you leave your lease early, it automatically means all these fines. But you can talk to your landlord. You can try negotiating. You can say, hey, I kind of want to leave early. I can help you look for a tenant. And you can negotiate a better deal without less fees, less fines if you work with your landlord. But typically, if you do leave early and you don't have any of these defenses, what a landlord has a right to do is they have a right to use that deposit money to pay for advertising to get the unit rented, the rent for the time that the unit sat empty, any reasonable termination fees, and these can all add up pretty quickly, where it's very likely you won't get your deposit back, or you'll get only a small part of it. So if you do have to end your lease early, again, I would recommend talking to your landlord, trying to negotiate, trying to say, like, hey, is there anything I can do to help you get this filled so that I don't get charged as much as, as the whole deposit, because I want to keep most of my deposit back. And that's kind of how you would go about that. Again, when it comes to repairs versus normal wear and tear, regular wear and tear is, for example, if the carpet's aging, that's natural, that happens. Minor wall scuffs, right? Like living in a house, you're gonna wear it down. That's what happens. However, that's different than like a large hole in the wall, right? That's not normal wear and tear. If something is a broken fixture, like a broken light that was caused by playing soccer inside the house, for example, that's beyond normal wear and tear. And so when you start moving out, it's important, again, like I said, with your move-in checklist, make sure that you know it very clearly at the beginning and then very clearly at the end. I recommend doing like a walkthrough with your landlord at the beginning and at the end, again, because it's important that you both agree on the conditions before and the conditions after. And again, I recommend also taking photos, videos, if there's anything that's contested. If, for example, you disagree on whether something is wear and tear and something, or if something is actually like damaged, what you can do is take pictures before and after, and if it goes to court or if it goes to a dispute, mediation, you have that evidence and you can say like, hey, it's actually not, this is normal wear and tear. This isn't any crazy amount of damage that I should be paying for. So yeah, again, this is why it's super important to keep everything in writing, including your move-in, move-out checklist, right? Take photos if you can. Hopefully, there isn't any problems, right? Like you all agree, there's just wear and tear, you kept the apartment clean. There isn't anything that is worth deducting. In that case, or even if they only deduct part of it, a landlord has to give you your security deposit or the remaining of your security deposit within 30 days. With an itemized statement of anything that they might have deducted and evidence of that. If they don't give you that deposit back, they can actually forbear to keep any part of it. So it's super important that they follow through with that 30-day deadline. If they don't, what you can do is you can write a demand for that deposit back. We'll have a template of what that looks like on our resources table. But yeah, they can't keep their deposit more than 30 days after you move out of your house, or your unit. If they do, again, you can go to small claims court. After you write a demand letter, you keep your evidence, and they can possibly award you up to twice the amount of the original deposit if they refuse to give that back to you. So good to know, important to keep track of everything so that you can prove that when you're making your case in small claims court, if it comes to that. The other way you can be terminating your lease is through eviction. That's not the worst possible outcome. Eviction is it's the whole process. We can spend an hour, its own hour presentation on talking about eviction, but I'll just kind of go through the basics of it. And if this is something that you do go through, we recommend you make a consultation with us. Or there's other amazing resources like the Housing Justice Project if you live in King County. We'll kind of go over that. But this is just like a general overview of what eviction is and what that process looks like. So there's a couple ways that a landlord can start the eviction process of trying to end that tenancy with you. For example, these are just a couple of them actually, there's quite a few, but these are the most common ones. If you don't pay your rent, they can provide a 14-day or 30-day pay or vacate notice depending on your specific situation. If you violate your lease, an important aspect of your lease, I should say, they can give you a 10-day to comply or vacate notice, meaning you have 10 days to start following the rules, or they can begin the eviction process. There's also waste, nuisance, or unlawful activity. That's pretty vague, and even the statute defines these pretty vaguely. But the most important one is if you're doing unlawful activity, they give you 3 days to stop, or they can start the eviction process. If the landlord wants to move in themselves, if they want an immediate family member to move in, they can give you a 90-day notice and have that process begin, basically. You don't really, unfortunately, if they want to move in, you don't have, given the 90-day notice, you don't have, you have to comply with that. If they want to sell the house, they have to give you 90 days notice, but they can do so as well. If they're trying to renovate, demolish, they have to give you 120 days notice. If you live with your landlord and you share, for example, a kitchen, if you share a bathroom, if you share a living room, that's a different circumstance in which they only have to give you 20 days notice before before ending the lease in that case. If you intentionally lied on your rental application, and it's a pretty big lie, they can give you a 30-day notice before ending the tenancy. And if you're not on the lease and the person that is on the lease is moving out, they can give you what's called a 30-day notice to apply to be on the lease or move out yourself. So once they give you that notice, after that time passes, they can then give you what's called an eviction notice, or they can start the eviction process. However, what that means is that if the time passes, that doesn't mean you're getting kicked out, right? That just means the eviction process is starting, which means it's a court process where then you would talk to, where you would talk to an attorney, begin that process. But just because they give you a 30-day notice, for example, 30 days pass, that is not by any means the time in which they can kick you out. That is a time in which they can start the process of kicking you out, but they still have to go through the whole process before, which ends with a court order from a judge. That's the only way that they can legally kick you out, is with that court order. Without that, you have a right to stay in those premises while you fight that eviction process. So before we get to our Q&A, we're going to have our wonderful peer navigator, Stephanie, talk a little bit about housing resources, and then we'll get to some questions.
Hello, everyone. My name is Stephanie. I am the peer navigator. My pronouns are they, she. It is so nice to see everyone. And I'm here to talk a little bit about resources. So as someone is going through legal challenges or housing challenges, they may need some resources, and that is what they come to me for. Usually when I'm working with individuals, I have an abundance of resources, and they are usually pretty individualized. So today I'm going to cover a few that are very general that may be applied to a wide variety of folks. Some of them may be like 211. So 211 can be used for referrals, financial assistance, legal help, housing advocacy. Sometimes when I'm talking to peers, we may make a list of a couple of those places, and I may help weed out like the hours, who has capacity to support them, what their support looks like. We may reach out to the Tenant Law Center, which offers legal help for low-income tenants facing eviction subsidies, or the Tenants Union, which helps them understand a few more things around their tenants' rights and organizing community action. I believe that the Tenants Union also has a really helpful line that you can call to receive support with. Another one that we may also utilize would be Solid Ground. Solid Ground has some really great tenant services. They have education programs. They have information in English and Spanish, which can be really helpful. And I think this was touched on a little bit, but some of the Washington law help resources can be really helpful as well. And some of the things that I may do with peers around Washington law help is maybe doing the searching with them, taking a look at which forms are required, what are they needing to fill out, what are they needing to bring, especially when we're reaching out to another legal organization, a lawyer, planning for appointments, things like that. We want to help them meet their goals, maybe take a look at the evidence that they're bringing in and help them set up like a list of things that they would want to show to lawyers or organizations who may be supporting them. Another thing that we may utilize would be the low-income housing searching, right? So the Seattle Housing website.org has a bunch of low-income housing, and that's all different types of programs, subsidies, services for elders. We may also utilize some rental assistance. There are a couple programs within our county and city that support rental assistance. A couple that I've seen help our peers would be United Way of King County and St. Vincent de Paul. And then some more like general resources that we may utilize. The Washington State LGBTQ Commission has a resource hub, and in there you can find all kinds of resources. So we may make a list of different types of places that just offer really affirming support while someone is navigating housing challenges or legal challenges. That may look like reaching out to Traction, which offers support for transgender and gender diverse communities, taking a look at the King County Trans and Resource Referral Guide. There's also even just a Seattle Queer Housing Facebook group, which can be really helpful in just kind of finding roommates, finding more information, finding housing that feels affirming to us. We also really like to highlight the Renting in Seattle website and the SDIC renting website. They have a bunch of different information on notices, the process of moving in, moving out. If you have any kind of issues, they have really great FAQs. And within this type of work, sometimes our resources look a little bit different from the housing stuff, right? As Christian mentioned, there may be service animal support, right? So that can look like looking through different directories to try to find a mental health provider that could provide that emotional support letter, right? So some of the ones that I really like to utilize is inclusivetherapist.com. They have a really great directory where you can look for insurance, you can look for modalities, you can look for someone who matches your demographics. Within our program, it is really important that we are doing our due diligence in finding services that feel affirming for our peers. And so talking to our peers is a really big part of what we do in figuring out what services would feel really helpful to you and what services maybe haven't been the most helpful to you. So that's a little bit about our program, some general resources, and I would be happy to answer any questions that y'all may have.
Perfect. Thank you. Thank you. All right. We can just stand up there together. Awesome. Okay. And if I could just highlight a couple of the resources here. If you have any questions, not even about housing, literally just about any legal procedure, family law, immigration even, they have so many resources. Washington Law Help breaks down so many really complicated legal topics into something that we can all understand. I use it a lot, so I really recommend it. And then if you do go through that eviction process, and if you do live in King County, the Housing Justice Project is phenomenal. They do eviction defense, and there are wonderful attorneys there that will help you navigate that process. So now we're gonna have our Q&A. I do have a couple of questions from the get-go that was asked by people registering that I'm happy to get to, and then we can get to specific questions, like from the audience. So the first two questions are similar. First one is, how does QLaw view the difference between corporate and local landlords? And the second question is, can investing in housing be a pathway to build prosperity in LGBTQ communities? And so these questions aren't necessarily legally informative based. They're more like philosophical questions. I think they're more, they're subjective. I certainly have views on these questions. They're not QLaw's views specifically. We can, if whoever asked these wants to talk about them, I'm happy to talk about it afterwards, but these questions don't really have a legal answer, so to speak, if that makes sense. Third question is, how can renters in URM buildings, URM being unreinforced masonry buildings, so ensure that their property managers are not using earthquake retrofitting renovations to illegally increase rent. So some buildings here in Seattle are pretty old, don't have the earthquake protections that maybe should be in place, and some of these buildings have to go through renovations, which can be costly. Regardless of whether you are in that building or any other building, all landlords and building owners have to follow the same law, which is that they cannot increase rent more than 7% plus inflation, which is about 2.7%, meaning that in any given year, a landlord cannot raise your rent by more than 9.7%. Regardless of whatever situation that they find themselves in, whatever renovations they have to do, that's the law. The only exception is if you live in a building that's less than 12 years old. They don't have that 9.7% limit. And then another exception is your rent cannot be increased for your first 12 months of living in a place. So even if you have a 6-month tenancy, for example, they cannot raise your rent at that point. You have to be living there for at least 12 months before you see a rent increase. For a rent increase, you also have to be given 90 days notice. In Washington State, in Seattle specifically, you have 180 days, so 6 months. You have to be told, hey, the rent's increasing by then. If they don't, they cannot increase the rent. I actually had a situation where I was living in an apartment. They tried to increase our rent. They gave us a 3 months notice, but in Seattle, it's 6 months. So on the very last day, before they were supposed to increase the rent, I actually wrote a demand letter and said, hey, you're not complying. And because of that, they had to reissue a notice with another 6 months before they increased the rent. So it really is important for landlords to follow these rules, or else they cannot raise the rent, for example, in that instance. The last question that we got before for like our registration questions was a situation in which someone says whether tenant-friendly ordinances in Seattle could operate to lessen the inventory of available housing due to putative landlords' reluctance to fall victims to tenants working the system. This has actually come up several times for me in my private practice, where people with a rentable mother-in-law or ADU have opted not to list their property for rent out of fear that the court system will not protect their property rights if things go sideways. So this question sounds like it came from someone on the landlord business owning side. And while this presentation is more geared towards tenants' rights, something that I would recommend is if someone wants to rent out a property and is scared, I guess, a property manager is a great way to ensure that you are complying with every single law set in place. Sure, it takes up. Sometimes they'll have a fixed cost. Sometimes they'll take a percentage of the rent, but it's a really great way to ensure that you're following all the laws, which can be complicated, right? There's also a lot of resources out there for landlords to make sure that they're complying with the law. But I would say that these laws in general are for protection of tenants, which are great, right? And as long as you comply with these laws, there shouldn't be a problem there. But those are the questions that we were given beforehand. Does anyone here in the audience have a question, something that they'd like clarified? Yes.
Can you show that slide with the dates, the 30 days, 90 days?
Yes, of course. Yes. 30 days. Wait, which one exactly?
The eviction thing.
Oh, eviction one. Yes.
Have 30 days, 90 days.
Yes. Yes, this one right here, right?
Yeah.
Okay, perfect.
I do have a question. So not this one. Keep it. I want to take a picture.
Okay.
You mentioned that the landlord needs to have 48 hours, even if for repair. And then this is in conflict with the previous definition. If, say, your water goes bad, they have to fix it within 24 hours. These two are in conflict, right?
Can you repeat like the 48 hours one?
So the 48 hours is like, you said the landlord cannot come to your apartment until they give you a 48 hours advance notice for repair.
I see what you're saying. Well, So the first one, the 24 hours, that's when you give the landlord notice. You say, hey, this isn't working, and it's like heat, or it's my water is not working. These are really important. Then they have 24 hours to get it fixed. But let's say, for example, right, to arrive, correct, yes. But that's, in that case, you're asking the landlord, hey, can you come and fix this, right? And then they'll tell you, yes, I'll come tomorrow morning, for example. That's less than 24 hours. We'll have someone get over there and repair it, right? That's different than them saying, hey, I need to go in and do, like, for example, regular maintenance, right? If they are requesting you to go into your building, then they have to give you notice, if that makes sense. So it's different circumstances.
For repair, usually something happens, otherwise why need the repair? And also water heater fix is not a 24-hour thing. Like my building had a water heater problem. And the manager, we have a manager, reached out as soon as he knew it, but he couldn't get anybody to come within 24 hours. So we were out of hot water for like 2 days.
Okay, yeah.
Building, okay, not just my apartment.
Right. And so I guess in that I mean, if they start addressing it, I think then they're in compliance, right? Because as long as they're trying to address it, technically, if it does take longer, you can try to seek some other form of remedy. However, if they are giving, like, it seems like they're giving their best intent, they're starting that process.
Yeah, every night there is a notification saying, okay, we couldn't get it done. So
Right, but if it does seem like it's taking like multiple days and it doesn't seem like they're genuinely trying, at that point then you can start. You can say like, hey, you're way past that 24-hour deadline. You're not complying with these laws, right? And again, depending on how long it takes, the severity of the situation, you can then start seeking remedies after those 24 hours, right? So it's really
I really think 24 hours is very, very tight. It's almost unlikely everything can be fixed right away 24 hours.
sure, and maybe it's not like it's not like realistic in every single instance, but within 24 hours notice, at the very least, they have to begin that process. If it's taking longer than that, you do have recourse as a tenant to start, demanding that get fixed. Any other questions? Yes.
What if I'm looking to enforce one of these rights and my landlord has violated one of the tenant's rights laws? What action should I take? Is there something I should do on my own? Should I reach out to a lawyer? How should I respond when a right is being violated?
That's a really good question. I would say it really depends on the situation. There's different ways that you can react to it. Let's say you have a really good relationship with your landlord, and you want to keep that relationship. What you can do is try talking to them at first, right, and saying, "Hey, I noticed that it's been a week since my fridge stopped working. I told you about it. What's going on, right?" However, if you know that your landlord doesn't care, they're not a great landlord, it's already adversarial to begin with, then you can, after the 48-hour deadline, you can then start that demand letter, right? You can, or if you need help writing a demand letter, don't know what that is, you can then talk to a lawyer, reach out to us, for example. We can help you draft that demand letter that begins the process of documenting, like, hey, this hasn't been working for 48 hours. And then, again, if things remain not getting fixed, you can take it all the way to small claims court, right? And then just try to get damages that way. Or if really there's nothing getting fixed, you have a right to move out without any consequences if things are no longer habitable. So there's different options depending on your situation, right? Depending on how you want to move forward, but it really does depend. And if you don't know how you want to proceed, then I think that'd be a great time to seek legal help or getting a legal consultation there.
Will you repeat the question before you answer it so that it goes through on the live stream?
Yes. Sorry, my bad. The question was, if my landlord doesn't comply with any of the specific laws, what recourse should I follow? Whether should I immediately, become adversarial? Should I talk to them first? And again, my answer was that it depends on the situation and how you want to proceed with that relationship. Any other questions?
I have several questions.
Oh, I don't think this is, now it's working. Good job, Courtney. Okay, my first question is, what protections do you have in terms of like trying to organize within your building? Like, for example, I left a note on the door that was like, can we make a group chat? Because we're repeatedly having our water, shut down without notice. And then like the landlord ripped it down later that afternoon before I could get like some of the people's numbers. And I was like, I know that there's like protections about like trying to organize and unionize at like workplaces, but does that exist in the context of like being a tenant?
That's a really good question. I know that landlords cannot retaliate in terms if you try to, talk to your other tenants. What specifically protections there are, I think it depends on the situation. So if you'd like, what I'm happy to do is talk to you afterwards. I'd love to hear a little bit more, and then I can tell you. But long story short of it is they can't retaliate for something like in that situation. They can't, but they certainly can't start any type of like eviction process. That's and if they try to make some other excuse, that then again you have anti-retaliatory protections. Specifically, if whether or not they can or can't like destroy down any signs, that's a little bit more nuanced, and we'd have to get into the more specifics, which I'm happy to talk to you about. But you cannot get it. That's not a grounds for eviction there, and you do have a right to talk to your other tenants and talk about these things without any retaliation.
Mm-hmm. Thank you. And then is there any like standard like pricing for like laundry, and is there like enforcement of that? Because it sounds like from what I hear talking around Seattle, like there's such a huge variety in laundry prices, and I'm just wondering if there's any kind of like protections in terms of against like landlords just pricing laundry whatever they want to price it at.
That's a really good question. To my knowledge, there isn't. I'm happy to look into it a little bit further, but there's nothing that I know of that sets like a standard for those types of services. Yeah.
Great. And then one last question.
Please.
Is this is a very nitpicky question. Are like hanging paintings on the wall like nail holes, is that considered normal wear and tear?
Great question. I think I would say it depends on how big like the holes would be. Again, in those situations, I know it's relatively easy to cover them back up, right? I know that I'm not like super versed on like the Home Depot things, but I think there's specific things that you can like cover up. I also know that there's like the like stick, some pretty strong like stick hold and stick that could like hold the paintings. If there's like if it's like a significantly large hole, I think you can make the argument for it. But if it's like a smaller hole, I would recommend. I would certainly make the argument that it's regular wear and tear. But if your landlord fights you on it, again, I think it's something that you might just wanna just try to fix, right? Because they could then charge you like an unreasonable amount for that when they try to itemize it. So that seems like something that I think. Again, and again, you could fight it. You could say this is normal wear and tear. To what ends? You could try to mediate it, go to court. But again, with smaller things like that, I personally would just try to fix it, and then argue like this fixture, it's fixed. This isn't. Mm-hmm. This is regular wear and tear, right? So yeah, it was those situations. I would say that I think that's normal wear and tear, even if a landlord disagrees. I would say you have options there.
Great. I know I said I had no more questions, but I have one more question.
Please.
Which is just, do you have helpful resources for navigating like healthcare related things, or is it specifically tenant related resources?
Yeah, we whatever someone may be going through with their legal challenges. So, like I mentioned, if there are people who are wanting a mental health provider, trying to find like accommodation letters, things like that. Peers will share their insurance information with me, maybe a little bit about their preferences around providers, demographics, the way that they would like to receive care, and what feels affirming to them, and then I will support them in doing a search. I will ask them if they have transportation, if they have like certain areas they're trying to avoid, or certain providers they're interested in, modalities, things like that, and kind of support them. I am not a provider myself, I'm not a therapist, but I am there to talk to them about their options, and so that is totally something that we can support.
Awesome. Okay. Thank you.
Thank you so much. Any other questions from folks? Also, if you don't want to ask your question out loud, we will be over there and up in the front if you wanted to talk about any specific situation or go deeper into a matter like the, organizing question. But for now, any other questions? Oh, yes, we got one more.
When my lease is coming to an end, if I want to renew, and start a new lease, if I want to stay in my apartment, does my landlord have to offer me a new lease if they don't have one of the legal reasons to end a tenancy?
That's a really good question. I believe, I think that they have a right to end terminate that lease at that point. But the most common qualification on a lease is typically they'll convert to month tenancies. Whether or not you can, you have a right to stay there. Again, if there's no reason, I would be hard pressed to find a reason for them to start that eviction process. But I believe that it's within their right to end that relationship then and there, without any specific reason, because the contract is terminated. And I believe, again, good practice would be for that landlord to state that affirm that the lease is ending. But again, for the most part, typically the lease will specify what happens at the end of the lease, whether it becomes a month-to-month or whether a new lease would have to be formed.
I'll just talk loud. So I know sometimes when a lease converts from a term lease to a month-to-month lease, they can charge you like a month-to-month fee on top of your rent. Are there any laws that limit the amount they can charge you for that extra fee?
Can you tell me more about that month-to-month fee? What does that look like specifically?
So my lease, my year-long lease just ended, and there was a provision in the lease that it would convert month to month. But if we didn't sign another term lease and we just kept month to month, they added on an additional $200 per month for it being a month-to-month tenancy.
Gotcha. Well, it's within their right to increase the rent, as long as the $200 is under the 10%, the 9.7% rent increase. If again, I think what they're trying to do, right? They're trying to incentivize you to stay longer, to sign a longer lease, in which case they can hopefully either not increase the rent at all or increase it less than that $200. But again, I think so long as the $200 stays within under the 9.7%, that is within their right to do so. Unfortunately, yeah.
Thank you.
Mm-hmm. Any other questions? Going once, going twice. Okay. Thank you all so much. If you want to get involved more with our organization, all of our socials are at QLaw Foundation. You can also join our newsletter by going on our website, qlawfoundation.org/newsletter. And we're always looking for volunteers. If you are an attorney and you want to help out your community, you can help out with our legal clinics. And we're also looking for non-attorney volunteers as well. And again, this concludes the speaking portion, but we will be at both our table outside, and I will be at this table over here. We have some really cool resources, some templates, like for example, template for asking an accommodation, templates asking for repairs. If you want to check that out, or if you have any specific questions, we're happy to talk. Yeah, I think that's it. Okay. Thank you.